You brought a lawsuit against your doctor claiming that he was careless and failed to timely diagnose your cancer. And now during the course of your lawsuit, the defense wants to get copies of your medical records having nothing whatsoever to do with the key doctor that you have sued in this case. Do we have to turn over those records? Are we required or obligated to turn over those records? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so let's say you brought a lawsuit against your doctor claiming that he failed to timely diagnose your lung cancer, for example. And now as a result of that, the cancer has spread. And during the course of the lawsuit, we are obligated to provide the defense with copies of your medical records. We are obligated to provide the defense with permission slips that we call authorizations that will allow the defense attorneys to get copies of your records, your medical records, from the various doctors and hospitals directly. So now, this entire case revolves around an internal medicine doctor, for example, or maybe a pulmonologist, or maybe a gynecologist, right? And now the defense turns around and says, hey, listen, we want to get copies of your client's foot doctor records. We want to get copies of your client's dental records. We want to get copies of your ENT records, your ear, nose, and throat doctor. We want to get copies of your ophthalmologist's records, your eye doctor's records. And you're thinking, wait a second, what does any of that have to do with the claims that you have made in this case? And the answer is absolutely nothing. What does it have to do with the defenses in this case? In most instances, the answer will be absolutely nothing. So why then might we have to turn over those records? Why might we be required to actually turn over a permission slip so that the attorneys for the defense can now actually go ahead and get copies of your podiatry records? You want to know why? Because this phase of your lawsuit is called discovery, which means the defense is entitled to a lot of information that they may not find useful or may not be able to use ultimately if your case goes to trial. But they won't know that until they actually request those records, go through them, and determine for themselves whether or not this is useful for their particular case. So why are we obligated to give them that information? We're obligated to provide those records precisely because, the defense doesn't know what's in those records. They may think that you may have made comments or complaints to those various doctors during the period of time for which you are claiming that this one or two or three other doctors who you now claim failed to timely diagnose your cancer. They may believe that you also complained to these other doctors as well during that time period. And the only real way that they can go ahead and confirm or validate for themselves whether or not that's true is if they go ahead and get those records. So now they are going to obtain those records, scour them page by page, and look to see what exact complaints you made on each and every visit to every other doctor that you saw. They want to rule out, they want to make sure that you didn't make any complaints to anybody else. Now, what happens if you did? If you did, now when it comes time to question you during your pretrial question and answer session known as a deposition, they will ask you questions about who else you made these complaints to. And now they will already know the answer. Why? Because they will have obtained your medical records, and they can see right there in those records themselves that you made a particular complaint to the foot doctor about a lung complaint. Or you made a complaint to your dentist about something involving pain that you were having. That might be a suspicious finding that now should have led them to do further testing or sent you out and referred you out to another doctor. So they're looking for different ways to point fingers at other doctors, at other healthcare professionals, to say, hey, don't blame us for what happened here. Instead, they point fingers and say, hey, look at what Dr. Jones should have done. The patient complained about these things to Dr. Jones, who is a dentist, who is an eye doctor, who is an ENT doctor, and they should have had enough seichel, enough knowledge to go ahead and say, hey, you know what? There's a problem here. You need to go back to your internist. You should go to the emergency room. You should go get testing. You should get a CAT scan or an MRI. And now, because they didn't, guess what? This patient's diagnosis was delayed, and don't blame us for that. Here's a doctor who saw the patient in between coming to see me. You know what? That argument may have some validity if the facts support it. But that is the reason why the defense will oftentimes ask for medical records that you believe have nothing to do with the claims in this case. But you should know, during the discovery process, the defense is likely going to get it. They're likely entitled to it. And if we refuse and fight them on it, you know what will happen? Now they'll ask the judge to intervene. The judge will turn around and say, why aren't you producing these records? And if we can't give them a good solid answer, guess what? The judge is going to yell at us and tell us, turn it over, counselor. Hand over that authorization slip, give them a copy of those records, and let's move on. So why do I share this great information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases here in New York. You know, I understand you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit, but are thinking of doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.